Welcome to Versus Trump, the podcast where we talk about how the Trump administration is breaking the law and what people are doing about it. I am your one and only host, Charlie Gerstein, here with Isha Anand.
It's funny to call yourself the one and only host when in fact you are just the one-off
One of
host.
three hosts, yeah. I am enjoying the introduction duties at this point. Jason is traveling, so am I, but I still managed to do my job here.
Whoa,
and
fighting words.
No, Jason actually is traveling in a much more fulsome way than I am. And seems to be having lots of fun with it. So he's taking this week off. And Isha and I are going to handle some important and unfortunately disturbing, as usual, topics. Isha, what's going on this week?
Despite being our, quote, one and only host, Charlie forgot to mention that you should tweet us at Versus Trump Pod, email us at Versus Trump Podcast, 2Ps, at gmail.com, and check us out online at the takecareblog.com/podcast. Okay, so topic for this week is a slightly weird one, hopefully one we can dispense with fairly quickly because it's just so ludicrous. Basically, this one's not a lawsuit, it's just a bizarre legal thing that Trump is doing that we've gotten a lot of questions about. So the headline is, Trump finalizing opioid plan that includes death penalty for drug dealers. So there have been leaks coming out of this White House for about 3 weeks now that some portion of the sort of master opioid plan that Kellyanne Conway has been working on is going to involve the death penalty for drug dealers. And on Monday at a rally in New Hampshire, President Trump kind of alluded to this in sort of more stark terms and he says, I'm all in on capital punishment for drug dealers. We're in an opioid crisis. So we got a bunch of kind of astounded texts when this news broke. And so we wanted to just walk through really quickly, kind of from a legal perspective, what exactly Trump is talking about and what it means. So we're going to start with just like the basics. When can you impose the death penalty per the Constitution? Then we're going to talk about how drug dealing potentially fits within that limit. Then we're going to talk about the sort of existing slate of tools at Trump's disposal, namely the federal death penalty statute. And then we're going to kind of wrap it up by sort of trying to figure out, is this something sort of new that Trump is pushing as he sort of seems to suggest at his rally? Or is this just the status quo that has been in place for several decades, as spokespeople for the White House and DOJ seem to insinuate when they sort of said, when asked about Trump's remarks, they said, in line with existing law and practice. So that's the setup. Charlie, do you want to start by just explaining does the Constitution let us execute people?
Sure. And it's not as easy as you would think, given how much law there is on the death penalty. So a brief history lesson. First, in 1972, the Supreme Court decides Furman versus Georgia. Anti-death penalty advocates thought that this was the end of the death penalty in the United States. The Supreme Court ruled that the death penalty statutes that were then on the books in almost all of the states were unconstitutional because they provided unbounded discretion for fact finders to execute people. 4 years later, as decided in Gregg versus Georgia, the states tried again and this time succeeded. There was also changing composition of the court, but by changing the way that their laws are administered to more bound the circumstances in which the death penalty can be imposed. And over time, the following sort of rough guidelines emerged in Supreme Court case law. First, somebody needs to die in the commission of the crime as a general matter. In Kennedy versus Louisiana, the Supreme Court rejected the death sentence of someone who committed a undescribably heinous non-homicide crime. In that opinion, though, they reserved the prospect that the death penalty may be imposed for treason and espionage, which are not crimes against the person, but instead crimes against the state, and maybe, just maybe, for something called, quote, drug kingpin activity. And we're going to be talking more about that later when we talk about the federal death penalty statute. Meanwhile, in another line of cases, the Supreme Court has talked about how state death penalty statutes balance what are called aggravating and mitigating factors. And these are what you think they are. Aggravating factors are things that make a murder worse, and mitigating factors are things that make it better. And the kinds of things that make it better, although not necessarily relevant to the actual crime, are the circumstances of the defendant. So history of abuse or mental illness, incapacity at the time of the crime in any sense, albeit a non-entirely excusatory one, stuff like that. And aggravating circumstances. Did you commit the crime for money? Did you commit the crime for some reason other than money? And the reason I laugh at this is they often do cut directly against each other so that it's aggravating one way or the other.
Every murder is an aggravated, yeah.
Yes. And of course, there's a certain conceptual incongruity here. Like, we're talking about a category of first-degree murders, and then within which, in some states, you have to not only have intended to kill the person, but have had something called malice aforethought, which is a particularly bad form of wanting to kill the person, which is to say you really thought about it and considered the prospect and then killed the person. And within that category, we're trying to figure out which are worse and which are better. But so is the state of the law. And Donald Trump's proposal appears to be to execute drug dealers
right.
for dealing drugs. But it's not as crazy as you might think.
Right. And so we should note, kind of before we get into the mechanics of how drug dealers can be considered murderers, we should note that, right, that the constitutional limits are only as solid as the Supreme Court's willingness to enforce them. And, the Supreme Court has not shown like a tremendous appetite for stepping in to halt executions. And in fact, earlier this week, the Supreme Court denied cert, so just declined to hear the case of a man named Mr. Hidalgo. And as part of his cert petition, the team that put it together had done this kind of empirical study that essentially showed that in Arizona, the state where he was sentenced to death, essentially every single murder could be death eligible. That is, the statute saying when you can impose the death penalty applied to virtually every murder. Like one of those circumstances, like Charlie said, they often have things like for money or not for money, and yet only a tiny fraction were charged capitally. And so back to the beginning of what Charlie was talking about, that seems like the sort of classic case of arbitrariness. There's no limits on or no criteria for determining which cases to charge capitally and which ones not to. And so it's got this kind of luck of the draw equality. And in that case, the four liberal justices, so Justice Sotomayor, Justice Ginsburg, Justice Breyer, and Justice Kagan, all drafted what's called a statement respecting denial, which is to say it's not a dissent from denial because there's four people who wanted to grant cert, then the court be hearing the case because it requires 4 votes to hear a case, but a statement respecting. And so there's who knows exactly what's going on behind the scenes. It could be that this just wound up not being the right case, but a lot of observers have kind of speculated. There are 4 people who thought this really does show that this scheme is unconstitutional. This is really worth paying attention to. This is a case worth hearing. And they just realized they weren't going to get 5 votes for the outcome they wanted. And so rather than take the case and have bad precedent on the books on this front, they decided to write this statement respecting denial. So anyway, so that's the kind of current state of play.
Yeah, and Isha, you can speak to this with a great deal more knowledge than I can, but I think perhaps one of the reasons why the Supreme Court has such a limited appetite for doing this, even though there are at least 3 solid principled opponents to the death penalty on the court now, is that just a hugely disproportionate amount of their time relative to the number of cases is spent on the death penalty. Because every time someone is executed in the United States, which is not as often as it used to be, but in my view more often than it should be, there's a flurry of last-minute stay appeals, habeas writs, challenges to the manner of execution, and they come up when they come, not always during the middle of the term and not always on the Supreme Court's luxurious schedule. And, these people like to jet off to Salzburg for the summer. They don't like to have to actually deal with, their jobs. And so I think there's just a lot of fatigue about the whole issue, which is really disturbing to put in those terms. But that is something you hear said.
Yeah, I think that's absolutely right. I mean, it's definitely, I found it the most horrible part of the job. You at the sort of end of the night of an execution, you do something called signing the death warrant if your justice is in charge of the circuit where the execution is taking place, which is basically you put your signature on a piece of paper that says the Supreme Court's not intervening, like go forth. And, it's not as though you're actually signing someone's life away, but it is the case that like your signature is the kind of final step in authorizing the execution often, which is a really terrifying responsibility. And I do think it's the case that a lot of the Supreme Court's time is spent on, dealing with the kind of flurry of filings around executions. But it is also the case, as you know, Charlie, that there's a great deal of uncertainty. There are these kind of various principles kind of hemming in when you can execute someone. There's sort of a general consensus that the standards ought to be really high and every I ought to be dotted and every T ought to be crossed. But one of the things I found astounding was how many people are executed where A, there's real uncertainty over the constitutionality of the execution. B, not all I's are dotted, not all T's were crossed. There was a heinous disbarred lawyer somewhere along the line, or new evidence that is yet to be DNA tested. Or C, where the crimes just don't match the kind of thing that we think of as the worst. Which I guess gets us to how could a drug dealer be said to be a murderer and therefore be eligible for the death penalty? So there's at least kind of 2 ways in which we talk about someone committing murder that doesn't require them to actually like shoot the guy, right? So The first one is something called felony murder. And basically the idea is that if you are essentially trying to commit a felony of some sort, sometimes it's a sort of designated felony, sometimes it's just a felony in general, and because of what you're doing to commit the felony, someone dies, or because of what someone you are working with to commit the felony does in furtherance of the felony, someone dies, you are responsible as though you killed that person. So like the kind of classic case is you are trying to participate in an armed robbery, it goes wrong, you wind up shooting someone in the process. It's felony murder in the sense that you didn't necessarily intend to shoot someone, but you intended to commit a felony. And it's because of the things you did to further that felony that someone died. And so it can be felony murder even if you participate in an armed robbery and guy dies of a heart attack because you pointed a gun at him, right? It's causally related to actions you took in furtherance of a felony, and you intended to commit a felony even if you didn't intend anyone to die. And so under that theory, basically what you say is you intended to commit the felony of dealing opioids. You sold a bunch of them to person X, who then overdosed, passed away. And so as a direct result of actions you took in furtherance of a felony, this person's now dead. That's felony murder. Charlie, I mean, do you see any kind of principled limitation or defense to theory number one, felony murder theory?
Well, I see no principled defense to the argument that can be felony murder under the law as you described it. There are lots of principled objections to the concept of felony murder, which is like unpopular in scholarly circles, although remains the law in most states and uncontroversially so. I can see several principled objections to executing people in these circumstances. So it's worth noting that states execute people for felony murders all the time. Like getaway drivers in armed robberies gone wrong, as Isha and I discussed off the air before the show, get executed like every few years. Like it definitely happens. And there is little principled distinction between that and at least serious drug trafficking, at least so long as we maintain the view that drug trafficking is a crime, which obviously we're going to continue to do. So no, not on that score. I do think, though, that we run back into the original problem with death penalty statutes under Furman versus Georgia, which is the sheer number of people that would cover is so vast that there can be no realistic principled limitation on who would get executed. And notwithstanding our worst fears of the Trump administration, it is genuinely unlikely that they would visit the death penalty on the full scope of people eligible for it under that theory. Now, there's a further limitation. We're going to talk about federal death penalty law, which is one thing that the Trump staff mentioned, which is to separate drug dealing from drug kingpin activity, which is to say big conspiracies involving violence and shitloads of narcotics.
Right. And so I should let me just explain quickly what conspiracy is, and then I'll kick it over to you for
the fifth. Right.
So the other way you can kind of wind up with a murder charge, even if you're just dealing drugs and you don't point a gun to anyone's head, is something called a conspiracy. And we talked about this before in the show, but this is basically the notion that you form an agreement to basically commit some kind of crime. And then everyone within the scope of this conspiracy is responsible for everything that everyone else in the scope of this conspiracy does. And so the way this would work is you say, you were part of a drug dealing ring. That is, there are a bunch of you who were kind of buying and selling opioid in conjunction with each other. You had this agreement about how things were going to work, and you divided up turf, and you had runners, or whatever. It doesn't have to be a particularly sophisticated operation. But once you've proven this agreement, you can then charge everyone kind of for everyone else's actions. And so you can imagine a situation in which you are part of this kind of drug dealing ring of some kind, that the United States proves that there was some kind of agreement, and someone in your ring, gave someone opioids that were laced with something else that turned out to be deadly. Everyone in the ring is sort of now responsible for that because it's something that the co-conspirator did in support of kind of the end of the conspiracy.
And it's worth briefly noting that for that to be true of the crimes committed by co-conspirators that you're not directly involved in, it has to be a reasonably foreseeable thing that your co-conspirators do. Another old Supreme Court case called Pinkerton governs that situation in which, you agree to do drug deals, and maybe you didn't intend that someone shoot someone else, but it's reasonably foreseeable that given the amount of narcotics that you're transacting in, that could happen. And there are federal cases like that. Again, this is another one of those circumstances that is heavily unpopular among the scholarly class because it allows for very severe punishments to be visited upon those without severe criminal intent.
Right, so and we should note that there is a further kind of constitutional limit in a case called Tyson versus Arizona, which is to say you have to at least exhibit, I think it's reckless indifference to human life. So it can't literally be that you're like, I had no idea this guy was going to have a heart attack, and then I gave him opioids, and then he did. You've got to at least show, there's got to be at least some kind of mens rea. It doesn't have to be that you intended to kill someone, though. It can be just that, like, you really weren't thinking about the consequences for human life. And if you thought about it for a second, you'd realize that what you're doing was dangerous and reckless. So Charlie, at this point, when does the federal government execute people in circumstances related to drug dealing?
So when can they and when do they are slightly different questions. When does the federal government actually execute someone? Very infrequently. Since 2001, it's happened 3 times. Timothy McVeigh, Juan Raul Garza, and Louis Jones Jr., not one since 2003. Under federal law, you can be executed, as I said earlier, for treason, espionage. Technically speaking, drug kingpin activity, which is worth noting, although lots of limitations have been placed on the death penalty since that statute was passed. Limitations placed by the Supreme Court under the Constitution since that statute was passed. So, no one's tested whether or not those provisions are constitutional. And so in practice, the federal government very, very infrequently executes people. And I think in part the reason for that is the Attorney General himself has to sign something authorizing it. It's extremely difficult. And the states seem to have no trouble executing people on their own. And lots of states. So, in Brooklyn, the Eastern District, I think several people have been sentenced to death who have not been executed. Lots of people, I think, have actually been sentenced to death who have not been executed. I think there are
presently 60-ish people on the federal death row.
Yeah. And, some of them were from Brooklyn, where they haven't had the death penalty in New York in many years. And, one of them is Dzhokhar Tsarnaev in Massachusetts, where Massachusetts hasn't had the death penalty in a very long time. And the people of Boston overwhelmingly oppose it, and lots of things like that. And so I think part of the reason why is in lots of the states where there is a federal death penalty, there is really strong opposition among the people of that state to the death penalty. So there have been people sentenced to death in Michigan. Michigan has never had the death penalty, not only while it was a state, but even during most of the period prior to it being a state. There's a very strong opposition to capital punishment. And so, you can see lots of reasonable federalism-based objections to imposing the death penalty in that circumstance, although none is legally cognizable. So it doesn't happen a lot. Under federal law, it can happen plausibly for circumstances like what we're supposedly talking about here, although I can't possibly speculate on whether Donald Trump has any idea what these limitations are. And it's also worth noting, if only parenthetically, that part of the problem with the felony murder theory, at least as Donald Trump intends it, is that it might actually cover a significant number of boardroom sitting white people, right? Like, he does not want that. Like, if you commit any felony in selling very dangerous drugs, you are a murderer who can be executed. That could plausibly include lots of large pharmaceutical actors. There's no evidence that that's ever happened so far, to be clear. Like, there is no evidence that anyone at a major American pharmaceutical company committed a felony in connection with any of this. I think that's a problem with how existing drug law is structured, but I just want to make clear, I'm not like slandering these people on the air here, but imagine that someone breaks federal law in the context of marketing prescription opioids and someone as a result dies. That person's eligible for the death penalty. Somehow I get the sense that that's not who Donald Trump has in mind, right? Like, he's not imagining white drug dealers because that's not what he thinks about. So there would have to be some way to structure this that he has that would create a principal distinction between those two things and make it less dreadfully obvious what he's actually up to.
Yeah, no, that makes total sense. I mean, yeah, I guess the kind of question then is, assuming that the federal death penalty is not presently authorized for the class of people we're talking about, A, does it make any political sense to try to push Congress to do this, and B, would such a law be upheld? And my instinct is no and no. So no, first of all, because a little bit of digging suggests, at least according to a few kind of survey studies, about half the people who are convicted under state felony murder statutes for drug dealing are basically drug addicts themselves, right? So like most of the time, the person you're ensnaring is not the kingpin. It's like mom or dad or cousin who's also an addict and is trying to figure out how to feed their addiction, and so winds up turning to dealing opioids. And then on the second question of like, would such a law be upheld? I mean, again, we've said the Supreme Court doesn't have a ton of appetite for these kinds of cases and for kind of putting more limits on the death penalty. And that Tyson case I mentioned, it's a kidnapping case, but at the time of the actual shooting, the guy who the Supreme Court winds up signing off on the death penalty for is actually saying don't hurt them and going to find them water to drink or something like that. I mean, it's still kidnapping and not drug dealing, but the Supreme Court doesn't require a ton of nexus. I have to believe, though, that at the point where someone is potentially going to have their life ended for dealing drugs, the Supreme Court steps in and says this is just disproportionate. And, the test under the Eighth Amendment, the ban against cruel and unusual punishment, is there's sort of an objective component, which is kind of like, how, what do most states do? What would most juries do? And then kind of a subjective component is kind of like, to what extent does this further the purposes of deterrence and retribution, and to what extent is it proportionate? And I have to imagine on all of those things, the answer is just not at all, right? It's not at all proportionate such that it can serve as retribution. It won't serve a valuable deterrent function, just because if we're right that most dealers are also addicts, that seems to kind of negate the value of sort of abstract death penalty. And the jury that actually comes back and says you're getting the death penalty for this has got to be an anomaly.
Yeah, and even if all of that weren't true, it's worth briefly mentioning as well. There's sort of another side of this case law I didn't mention because until now it wasn't relevant, which is, on the one hand, Furman says that states can't give juries unbounded discretion to impose the death penalty. But on the other hand, there's a line of cases forbidding mandatory death sentences, which is to say an actual fact finder, a jury, although in exactly one state a judge can disagree with that, has to find that the aggravating factors outweigh the mitigating factors. And definitionally, that can't be done on a mandatory basis. And so, in a crime that a huge number of people in this country commit, it's impossible to thread that needle. So under existing law, it would be reasonably easy to say it's either one or the other. Either you can do it to so many more people than you actually do it to, like orders of magnitude more than any number of state homicides. More people die in this country from drug overdoses last year than died in car crashes. It's the number one cause of non-disease related death. And so, I mean, just stunningly more people would be eligible for the death penalty than could possibly receive it. That I think you'd run into the problem in Furman. And if the alternative is the bloodbath world that surely Trump wants, which is everyone gets it, then you run into the opposite problem, which is it can't possibly be aggravated enough. So I think it's pretty clear that, he's not actually going to do this. Meanwhile, that's of course what he wants, right? He gets the saber rattle for the bloodthirsty base, make boogeymen out of certain people who are not actually the real perpetrators of this crisis. Call it a win, right? Doesn't have to actually do anything and is very unlikely to.
Right. Yeah, no, and there's a quote from a prosecutor in, I think, Palm Beach in a Politico story I was reading in preparation for this podcast, where he basically says, look, the number one thing that the federal government could do to reduce deaths is pressure China to end export of fentanyl, right? Coming up with stiffer penalties, in the wake of the first time in decades that there's been any push to recognize the toll that drug laws have taken on communities, particularly communities of color, and the first kind of major push to kind of reconsider our practice of just rampantly incarcerating people who are caught with drugs. The notion that the thing to do is kind of go back in time to the tough on crime 90s and figure that locking up tons of Black and brown people will somehow fix this problem just seems so naive.
Yeah, I mean, it's not naive. It's craven, right? I don't think that any of these people actually continue to believe this. Tom Cotton seems to kind of actually believe this.
Chris
He's a
Collins,
senator,
right? I mean, he's the one who says, "I'm all in on the capital punishment side for those offenses that would warrant that, including drug cases." Yeah,
although I was recently reading an interesting book about how in the Nixon administration said the same thing publicly and then privately would say to one another in memos, "We all know this is bullshit and it won't work." It was quite that craven. And, there's no reason to believe the same isn't true here. Although You're right that Collins and the rest of them fall into the same category because they publicly say they really care about this. That's not to say they actually do. You'd really have to be an idiot at this point to think that this is how we're going to solve this problem, given the Clinton administration's experience with this, the Nixon administration's experience with this, the George W. Bush administration's experience with this, right? This is a problem we now understand is not solved in this way. And yeah, there's been some real push in treating this differently, I think in part because now this epidemic has really expanded its grip on the white population in this country as well. So there's at least should be some hope that we'll be able to focus on this as a public health problem, which is, of course, what it is. But you never know. No, mercifully, this is, I think, one of the rare circumstances on versus Trump where we can safely say this is not going to happen.
Right. I mean, never say never, but yeah.
Never say never. Yeah. I mean, we still have institutions capable of enforcing legal norms. Like, that's a predicate to my answer here. But
right. Absolutely. And I think the other thing to kind of keep in mind is to think about, the federal government is a government of limited powers. There's got to be, theoretically at least, although this requirement is so loose as to effectively be non-existent in most cases, there's got to be kind of a hook related to interstate commerce. So you can imagine with a drug kingpin, that's easier to show. With the kind of individual opioid dealer, maybe harder to show. But one of the reasons that conservatives often want to enforce this limit is because they don't want regulations related to handguns. And you can very easily see how whatever felony murder theory gets you to executing someone who dealt drugs to someone else who then overdosed also gets you to the arms dealer who sells handguns without a license, right?
Yeah, and I think this fits into a theory that I won't speak for you, but I think we both agree with, of Commerce Clause limitation jurisprudence in the Supreme Court, which is it's one-off, right? They've done it 3 times recently, and one was the Violence Against Women Act is unconstitutional to the extent that it makes state law criminal defendants stand for tort damages in federal court when they abuse their spouses. Right, like it's a real one-off decision there. And then the Gun-Free School Zones Act is unconstitutional to the extent that it regulates someone who possesses a gun purely intrastate near a school zone. Okay, and the Affordable Care Act is unconstitutional, at least under the Commerce Clause, when it requires you to buy health insurance. And there's no other content to that rule, so the federal government can do anything but those 3 things.
Right.
And this is a very well-suited time to have a new one, which is no mandatorily executing drug dealers, right? Just like a magical decision that we're not going to do that. And you could see this being one of those. And I will cite to the article by Richard Primus, guest and friend of the show, explaining that theory that I just laid out in both much more detail and much more accurately.
Is there anything else to say on this topic? I mean, I feel like that idea, probably unconstitutional, always not a great sign when your president's mimicking, leaders that have been found on the international stage to be slightly unhinged. Sorry, I'm referring to the president of the Philippines, Rodrigo Duterte, whose sanity has been called into question and who is really big on not just executing drug dealers, but like vigilante style executing them, like extra legally doing so. Yeah, I don't know. Anything more to say about this, or just like a particularly terrible announcement?
No, it's just another depressing announcement from the Trump administration that hopefully won't go anywhere and has no legal basis. And makes our jobs in some ways easier, but emotionally more difficult. and on that delightful note, friends, we will spare you the remainder of our musings for the evening. And you know how to tweet at us and to
first,
whatever
Charlie,
else at
I
us.
want to hear you talk about a Trump nug that's right up your alley.
Oh, okay. All right. I'll do this very briefly, Trump nug.
This is such a Charlie Trump nug.
This is, I mean, it's when the shoe fits.
Right.
So Donald Trump shaking up his legal team in the Russia investigation because, they're trying to convince him to follow the law and make wise strategic decisions, and that tends to chafe on a man. And so as he's in the process of shit canning people or not, he has brought in someone named Joe diGenova, who has peddled genuinely bizarre conspiracy theories on Fox News about how the FBI and the Justice Department framed Donald Trump to make up for Hillary Clinton's loss in the election, and they sandbagged the criminal investigation against Hillary Clinton so that, even though she committed grievous felonies with her emails or some other such nonsense. And it really is this feverish, by the way. Like, that's not an overstatement of what this guy's theory was.
Yep.
And he is a lawyer representing the President of the United States as of recently. Why I bring this up now, though, his law partner and wife also represents someone named, his law partner, who is also his wife, not his law partner and his wife, represents someone named Mark Corallo, who was a spokesman for the Justice Department and who resigned for fear that he was being made to obstruct justice. That's a potential conflict of interest.
Not just a potential.
That is almost certainly a conflict of interest, right? I mean, you can imagine a circumstance in which you can screen 2 law partners away from cases where they represent clients with adverse interests. It's possible. Both clients would have to consent to that, but they would still have to enforce what's called sometimes oddly called a Chinese wall, which is to say a big, tall, or very long wall, or a wall that is difficult to get over. And, if they do that, it's not necessarily against the rules. It's not clear that they've done that. And it's also worth noting, and we'll link to this, a wonderful article by the late Bill Stuntz, who was a mentor of Jason's, and in which he describes one of the rationales for making these conflicts rules non-waivable, which is to say, even if all the clients here wanted to be represented by lawyers who have this conflict, and it appears that they do, criminal courts will step in and say you cannot do that because it allows people, exactly as we fear here, to illegally cooperate with one another to thwart the aims of the government. Right? One thing that these two could do is help everybody broker an illegal conspiracy not to reveal the truth of what happened. We have no evidence that they're actually going to do that, but the reason why we have conflicts of interest rules is so that we don't end up sitting around thinking about this. Yet another instance of sanctionable misconduct. This one actually might result in sanctions, right? This is I'm not a lone wolf out here on this one being troublesome. This is sort of uncontroversially troublesome.
Yeah.
And so, but yes, if the shoe fits, we talk about lawyers behaving miserably, at least tangentially related to the Trump administration.
Excellent.
And with that, we will actually leave you.
Right.
And I trust that you know what our email address is, and we look forward to hearing all of you next week.
Bye.
Bye.